All right, Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today's Wednesday, April 2nd, 2025. We have two quick bills on the voting list, on the hearing list on the docket today. So we're going to start off with Senator McKay with Senate Bill 1046.
Thank you, Mr. Chair. Thank you, members of the greatest committee in the Senate. Buttering up, buttering up. There you go, finest for all cares. Thank you for the opportunity to testify in support of Senate Bill 1046. This has to do with the Davis Martinez parole agent murder that happened. So as you well know, the order for the department to deploy body cameras outside its facilities must be changed in the statute, and this bill does that. The purpose of Senate Bill 1046 is simply put that the bill authorizes the correctional officers who are outside of the correctional facility and are interfacing with the public to use body-worn cameras. For example, parole and probation agents, correctional officers conducting transports, etc. This correctional officer defined is under Correctional Services Article 8-201. The correctional officers working outside the facility or campus grounds do not currently have statutory authority to use body-worn cameras. I do understand that House Bill 176, the Davis-Martinez Act, has been amended in the House to include body-worn cameras authorization language. But the current FY26 budget proposed for the Department of Safety and Correctional contains a $428,000 that is contingent for the approved legislation that gives the department the authorization to use the body-worn cameras. In other words, passage of 1046 unlocks this funding for hopefully House Bill 176, which I encourage everyone to vote for. Answer any questions the committee may have.
Excellent. Thank you very much, Senator McKay. Senator West has a question.
Yeah, I do. Thank you, Mr. Chair. A couple of years ago when we passed legislation requiring officers to wear body cameras whenever they interact with the public and have them on, and they not only video but also audio record people, I assumed at the time that that affirmative statutory requirement would override any possible contrary elements of the law, such as the two-party consent rule. So is the premise of this bill the idea that all these years that police now have been wearing body cameras in accordance with our statutory directive, that they have been in violation of the two-party consent rule?
No, sir, not at all.
Good.
This is just about state correctional officers and has nothing to do with detention centers in our counties.
Correctional officers. So we're talking about people running jails.
Well, the Department of Corrections, and it's for authorizing those correctional officers who are working outside of the correctional facility, such as interfacing with the public, like our parole officer that was unfortunately killed, and also conducting transports of.
Okay, and so the implication is that currently, if a correctional officer wears a body camera in those situations, that he's violating the law?
Well, they don't have the authorization to do that. That's what this would do, is change the statute to give them that authorization.
Fine, great.
Yes, sir.
Thank you.
Senator, thank you for bringing this bill. And it almost shocks you that this wasn't already the law, right? But so I can understand this, what is the status of correctional officers inside facilities? Because I would think for safety and other reasons, they would want to have the authority to wear a body-worn camera, and we should be financing that. Is that the case, to your knowledge?
My understanding it's not, but if I may, Mr. Chair, may I call someone up from the department to
and I have a follow-up
make sure that I have
yes.
crossing the right T's and dotting the right
Come on up, sir.
I's.
Good to see you. Yeah, so what goes on in the facilities right now?
So, thank you, Jason Davidson, for the record, Department of Public Safety and Correctional Services. Senator, to answer your question, so currently, you don't need statutory authority inside the facility. The reason why is because there's already an expectation that you're going to be on camera. There's already an expectation that there's no privacy, obviously, because you're inside a correctional facility. So you
Right.
don't need that statutory authority, which is
Gotcha.
why we're even able to do a pilot program currently at 4 of our locations. So
Oh, you do have one right now?
we have a pilot program
Okay.
at 4 of our correctional facilities inside the facility. This bill, as the senator mentioned, would give our correctional officers the ability to use body-worn cameras if they're off the campus. So again, transport, parole and probation, that kind of stuff.
And I didn't get a chance to read the bill, so, but I'm very supportive of it, but does it work so that, you know how with law enforcement, they have an obligation to turn it on under, you know, with certain circumstances, you know, kind of mandatory?
Yeah.
But what are the parameters of this bill?
So the bill mirrors current statute for public safety, Article 3-511. There are no, it does not define your question because
That's fine.
first we need the authorization. All the bill does is it gives authorization
Okay.
as the bill calls for the Correctional Training Commission to promulgate those regulations
Got
and
it.
the policy.
And then have you all been told that you will get the financing,
sorry?
you know, financial support in the budget?
Yes.
Is that going to
The
be?
currently, the budget includes $428,000 in the current fiscal 26
Okay.
budget, but it's contingent on this legislation passing.
The bill before us right here?
Correct.
All right. Thank you very much. Thank you, Mr. Chairman.
Good afternoon. Could you tell me more about this pilot program that you all are running?
So I know we're running a pilot program at 4 of our facilities, Patuxent, ECI, MCIW, and North Branch, MBCI, for correctional officers within the facilities to use body-worn cameras and to see how that's working out. We worked that out in conjunction with the union.
And what is it that you all are, law enforcement, I'm getting, so I'm assuming if you're doing it inside the facilities, is the camera running 24/7? I mean, during the entire time that the correctional officer is on duty? Or could you explain a little bit more about this program, I guess?
So Senator, I apologize. I was only here to talk about this, but I can certainly talk with you offline if you're okay with one of our subject matter experts about the details of the pilot that's currently running.
That would be helpful. So, but this bill is about when you're not in the facilities, outside the facility.
Correct, because there's not an expectation of being on camera outside of a correctional facility. So in order to interface in the public as parole and probation would, or if you're a correctional officer transporting an incarcerated individual off the campus, you would need that authorization.
So a correctional officer would use these when they're transporting someone from from prison to courts, I guess, right?
Possibly, yes. It would allow us the authorization if we wanted to do that, yes.
Between facilities.
Between facilities, because you're out in the public.
No, and again, I'm just trying to figure out what are the scenarios outside of the public.
Sure, if you're driving or transferring an incarcerated individual from a facility to another, you're on public road, you're to the hospital, yeah.
And I'm trying to think, is there something, what is it that, I mean, with police officers, I got it. There were a lot of incidents where things were happening. Correctional officers, I can think of, and it may be, I'm sure it's a number of other incidents, but I'm thinking of the one incident where I think an officer was on I-70, and if I'm not mistaken, they were murdered, right? What is it? I guess I'm trying to understand why they would need cameras, and what is it that?
I'm not saying that we
necessitates
would
it?
put cameras on a correctional officer that's transferring an incarcerated individual outside the facility. All the bill does, it allows us to be able to do that if we feel it's necessary in partnership with our partners.
And the only reason I'm asking.
It's a safety mechanism.
I've heard about parole and probation officers or somebody wanting them to have it. I think we saw there's a bill that was in the House that may have come over here with code enforcement, people with body cameras. Again, and I'm just trying to understand the universe, because everybody doesn't need a body camera.
Correct.
Police officers, I get it. Correctional officers, maybe. I'm trying to understand why I should vote for the bill.
So a parole and probation agent is defined as a correctional officer in the statute that the senator cited, 8-201, under the Correctional Services article. So using the term correctional officer encompasses a parole and probation agent, as well as other correctional officers that are working outside of the facility.
So parole and probation officers, they don't have weapons like law enforcement has weapons?
Correct.
Okay, thank you.
Thank you.
Thank you, Mr. Chair. Thank you for being here. Will you follow up with all of the committee on this pilot program? This is the first I've heard of it, and I'd like to learn more.
No, we can do that.
Thank you.
And I don't want to make this longer either, but I do want you to also follow up the committee. I assume there is an after-action look at what happened in the Mr. Davis-Martinez situation. And I'm assuming that, the cameras on your body are not the only thing that might have been helpful in the circumstances. In fact, I am terribly worried about the vulnerability, because I can imagine he could have had this camera on if that man wanted to overtake him, which he probably could have. Camera gets shut off and really didn't advance his safety much at all. So I don't know where that is, but I assume you could get back.
We'll be happy to brief you on that.
Yeah, I'd really like to have a briefing on that. Thank you, Mr. Chairman.
All right, further questions from the committee? Senator Sinor.
I'm sorry. The question that I have, parole and probation officers, they go into people's homes.
That is correct.
And that's pretty much going to be a large amount of time when they're kind of out in the field. So you have the situation where, people's, and again, I think there's a distinction between law enforcement officers and parole and probation agents who are then coming into your house and just to do a field check, but they're in there and they're also kind of have cameras on, tape recording your home. Has there been any thought about that?
About parole and probation agents going into the home?
Right, and the privacy concerns.
Sure, that's where the regulations and the policy would come into play to establish those rules. Again, this bill just gives the authorization to be able to use body-worn cameras, but the Correctional Training Commission will be developing that policy and the regulations on that.
But again, law enforcement officers, they're generally out in public when they're dealing with the public.
Yes.
The probation officers, if they're dealing with the public, they're usually dealing with the public. Either you're at the office or you're in somebody's home.
Yes.
All right, thank you.
Thank you, Mr. Chair. So when law enforcement are in a home, they make a notification, do they not, or any interaction, whether they're in a home or in public, when they engage with the public, there's known that there's a camera on them, and it actually, a lot of them wear it on their vest that says audio and video recorded. Are you familiar with that?
Okay.
And that's a requirement that's required for notification. But there's no requirement for them to turn that off, because that's for officer safety as well as the community they serve. Is that correct?
I'm not familiar.
Would you think, would that be?
I would follow that, yes.
Okay,
Yeah.
so in that same logic, in that we recently had a probation agent killed in Montgomery County, as a terms of condition of one's release, wouldn't it be a simple part of their terms or conditions of release that they know that they're, especially because their homes are automatically open for inspection? Are they not?
I believe so, yes.
So wouldn't that fall with it? What's the difference of being there with inspection or being able to have it, your camera on for the officers or the agent's safety?
I think the bill, so I know we're getting into the semantics of the usage of the camera, but again, that's why the bill calls for the policy and the regulations to be developed. The bill is structured as current statute is existed.
Right.
And that's how we did it just for the authorization purpose. I think those kinds of issues would be fleshed out during the regulation, the policy process.
Yeah, no, I agree with that. I mean, I really like the idea that, if we're looking at, we've had a very robust discussion about two-party consent this session. And when is an appropriate time to be able to record someone without their knowledge. This would be a time where they're reported as a condition of their release to be checked in.
Sure. We're happy to work with you on that. The CTC will be working, and I know you know them very well, so we're happy to have those conversations.
Thank you.
Excellent. Thank you very much. All right, further questions from the committee? Seeing none, thank you very much. Thank you both.
If I may, Mr. Chairman.
Yes.
There are a couple amendments that the union has, and that we'll get those to you, and we're very supportive of that, as well as the department. So, thank you.
All right, thank you very much, Senator McKay. With that, that'll end the hearing for Senate Bill 1046. We'll now move on to Senate Bill 1007. Just to speed things along so we can get to voting, I'm going to just take it from here, present it, and then I know Lisa Jordan will provide some additional background and context for the purpose of the bill. As Senator Folden and Senator West have alluded to, we've had a very robust discussion on the two-party consent statute. I've been very protective of that statute throughout my tenure in the General Assembly. Don't like chipping away at it. Obviously, there's some, and I think Ms. Jordan will speak to the, kind of the purpose and the rationale behind the bill before you today. Essentially, what it does is it provides for, so there are, obviously, if there are exceptions to the two-party consent rule, so there's an exclusionary rule, and there are exceptions to that exclusionary rule. In the bill, if you look on page 2, you can see the 3 exceptions that exist in current law for when you're recording someone. So one is if you're, obviously you have to have an expectation of privacy, but when there's an exception, one is that if it happened outside of the state during that communication. 2 is the interception was not made as part or in furtherance of an investigation conducted on or behalf of law enforcement officials of the state, and all the parties to the communication were co-conspirators to a crime of violence as defined in Section 14-101 of the criminal law article. This adds for another exception. And so the bill before you is actually, the language is pretty broad. And so I'm recommending an amendment to narrowly tailor this to fit the circumstance that we're trying to actually address under the bill. And the amendment that I'll offer, which is in concept now, but I'll have it in writing before we vote on it if we want to consider it, is to narrow it down to essentially a crime against a person. So, so that it fits the scenario that Ms. Jordan will present to you now. That means that if someone, obviously if they're in their home or in a place where you would otherwise expect to have some sort of expectation of privacy, and you record, let's say, your own assault, that you would be able to enter that into evidence. Otherwise, because of the two-party consent law that we have on the books, it's a felony, and I think it's up to a 5-year penalty. So this provides for the admittance of that evidence under those circumstances, and so with that, I'll have the amendment in writing before you, and I would ask the committee for a favorable committee report, but I'll turn it over to Ms. Jordan so she can explain a little bit about some of the client work that she's done and put some actual stories around the purpose behind the bill.
Thank you, Mr. Chairman, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault here in support of Senate Bill 1007 with the described amendments. And it's really designed to balance privacy, which we also believe is very important, with the need for justice. Some of the cases that we've seen where we're unable to seek justice include a child who knows that his mom was beaten frequently, and so knew that dad was going to beat mom, and so recorded the beating of mom. The audio recording of that beating could not be used in evidence. We've seen cases where multiple cases where people have audio recorded their own rape, and that has not been able to be admitted. And keep in mind, if there was a videotape, the video would be able to be admitted. This is just an audio tape restriction. We've also had cases where just a security system has recorded a threat of someone's life, and that has been not admitted. I I certainly, there are lots of issues about two-party consent. This is very narrow. Criminal proceedings, crimes against a person, these are people who they're creating danger in our communities. And so this is a good incremental step here. I think the other thing just to keep in mind is that this tracks the hearsay law. So this tracks very specifically the same catch-all hearsay provisions, and it is not automatic. The judge will look at all of those factors in the hearsay exception. They will analyze that, and they can still exclude the evidence if they feel that it's inappropriate, or they can decide we're going to go ahead and admit this. So it's narrowly tailored. I'll also just point out that this is not for law enforcement investigations. So may not be for law enforcement or at the suggestion of law enforcement. Those folks still have to go through the request of a warrant or wiretap order. So very narrow, but critical. I know there are so many questions about this, and we're just asking that you take this narrow, small step so we can see justice in these very dangerous cases.
Thank you very much, Ms. Jordan. And obviously, if you look at the bill, page 2, those hearsay, those factors that the judge will have to look into, those hearsay exceptions are enumerated there. I saw Senator Henson and then Senator James.
Thank you, Mr. Chairman. Thank you for the testimony and thank you for the bill. My question is about if it's able to be used both ways. And I ask because when I represented survivors of domestic violence, one of the ways that audio or video recordings would come into play is that the abuser works them up, gets them into the worst state that they can be in, and then hits the button when they don't have knowledge that they're being recorded. And then you present to court with this story of being abused, and then abuser has this audio or video of the person behaving wildly, but no context as to what happened before, and it really was damaging to the credibility of the person who is presenting in court, of course, sharing their story of abuse. So if we open the door for the audio and video recordings, would it be for defenses as well as for prosecution?
So it's my interpretation that it would be both ways. The judge would have the ability to obviously use those for any hearsay evidence, those same factors that are applied to this situation. But that's my interpretation of it. But
yeah, I agree with that interpretation, and I certainly have had that experience also, Senator Henson. But I do think that the factor, the interest of justice, will be best served by the admission into evidence of the contents of the communication and the evidence derived from this communication, just together with our rules that require, kind of the entire record being introduced, the need to have context. Make it an appropriate change to our law. I mean, we're allowing rapists to go free. Rape happens in private almost all of the time, right? And I understand the risk that you're talking about, but it's a balancing act, and we're letting the courts make that balancing assessment.
Okay, I'm happy to put that on the record, though, just a slight bit of caution that I feel on that, because if you're in a situation of domestic violence, very often the abuser is someone who's very capable and skilled at manipulating. So being able to use this new tool as a way to try to undercut the testimony of the survivor, I do think we run a risk there, but I certainly hear what you're saying in terms of balance. We have the ability to do a tremendous amount of good as well. So I appreciate it. Thank you.
Thank you.
I don't know who could help me with this, so it's just open to counsel, Lisa, or the chairman. Just right now, so I want to understand two things. One, just generally, we have cameras out on the streets. Now, I guess that you can put in evidence both visually. I don't even know if they record auditories. I don't know if they record sound, but that would be like no expectation of privacy situation, right? But I do know that many people now, put in cameras around their houses, for windows and, doors, and I don't know, maybe even some select areas inside. So currently, with those, if they had the ability to pick up auditory sounds, I don't know if they do, but if they did, and you had them for security purposes, what would happen in, what would happen with that kind of evidence or potential evidence for a court right now, irrespective of anything that's going on with this bill? How's that treated?
So you're completely correct, Senator James, that the first line of analysis is whether or not there's an expectation of privacy.
Right.
So, if you're out on the street, there's not going to be that expectation. If you're using the restroom in someone's home, there's going to be an argument about that. If you're
Right.
having a public meeting in your living room, I've had arguments with people talking about conversations with clients in the courthouse hallway. Is that private or not? So you look at that privacy. If it is private, then you cannot make an audio recording.
Okay, so the aspect of privacy is more of what's going to control than anything else. So if I have a camera in my house for my own personal safety, the visual can come in, but the auditory cannot.
That's correct. The audio cannot come in. And in fact, if you do have someone who has an expectation of privacy and you are making an audio recording of them, you're a felon yourself.
Right.
Right, so that's
Yes.
another issue.
So then, under this, as I understood the chairman, we're going to narrow the bill to a crime against a person as opposed to, I don't know, stealing TVs out of the house or something like that. But Senator Henson just brought up a good point about if we're narrowly tailing it to crimes against a person, then if a person perpetrating a crime against a person is also videotaping it, but in a different kind of manipulative way, how would that come in under this bill? And is that what we want to do, or don't we want to limit it to, people that are having a crime committed against them?
I think that what we're
I'm
saying.
confused, obviously.
Yeah, no, I appreciate that. And I do appreciate Senator Henson's point. However, part of this is about best evidence, right? This is important evidence, often the only and most important
Right,
evidence
right.
of a crime against a person.
Right.
So what the chairman's bill as amended is doing is saying in this narrow situation where you have an allegation of a crime against a person, we're going to allow the audio tape to be considered as long as the judge goes through all of these factors. It's got to be a material fact. It's not part of a law enforcement investigation. It's more probative on the point than any other evidence that could be gotten through reasonable efforts. Interests of justice will be served, and
I understand that. What
Yeah.
I'm trying to figure out is just, the law of unintended consequences. I understand that. I understand the analysis. So the person against whom the crime is allegedly being committed, somehow has recorded it and gotten an audio of it as well. But what Senator Hansen brought up, I thought was very interesting, because so if you have a perpetrator of a crime, he or she, I'm going to say he for right now, right, took a video with an auditory, but it was, manipulative in some way. I would expect that this bill doesn't cover that, but because this is not the person for whom a crime is being committed against, but maybe I'm not understanding how this would work. So both video, audio recordings could come in because it's just the umbrella concept is crime against a person. Okay, if that's something that's happening, competing video, audio could come in from both the alleged perpetrator and the victim. Is that your understanding of how this will work?
So Senator James, right now the video can already come in.
Well, yeah,
So the
I know.
restriction's only on audio.
I'm just trying to be super accurate about.
And unfortunately, we do have perpetrators, serial perpetrators of rape who take trophies, right? So they have trophy audio recordings.
Okay,
and so
yeah.
I would not want to restrict the prosecutor's ability to bring that evidence in.
Okay.
And I understand the concern,
Right.
but this bill does not say it always comes in. This bill says the judge has to analyze the situation and figure out under these factors if this is the best way.
I get that part.
And that's, I think that's
understand
the answer to Senator Henson's concern,
I'm just
is
wondering-
that
so
it's
I
not
guess-
automatic.
It's hard
Yeah.
to do this without language before you. I think I know if I'm not
It'll
answering.
help me.
Yeah, because it doesn't say that it's the victim of the crime, that it's just a crime against a person, period.
Right.
So it's not, as hard as, so it can go in either way.
Right. Well, now that I understand that, it's the umbrella idea that a crime against a person is being alleged. What, and I'm just saying video, audio, but that what audio comes in could be either source or regardless of source to some extent, if the judge goes through the probative value and all the other safeguards. All right, thank you, Mr. Chairman and Lisa.
Thank you, Mr. Chair. I'm looking at page 3, line 8, where it's asking for the name and address of the party whose communication was intercepted. Let's say I'm having an event at my house and I got cameras all throughout my house, and one of my guests brings somebody and that person assaults me in my house, but I have no idea who this person is and name. I don't know who this person, what their address is. I can get the name, obviously, from the person that I know who brought the person in. Like, how would I be able to utilize this evidence if I don't have the person's address? Do I now have to go hire private investigators to figure out addresses for people?
So Senator, I don't know if Ms. Jordan wants to answer that, but my impression would be that because it's a criminal case that would be applicable to. It would be the state that's, conducting the investigation and proceeding to offer that evidence. I'm trying to think of how that would play out on the other side. Well, yeah, I mean, I think in that scenario, it's the state that's doing the investigation and then would need to provide that to the defense.
The only thing I would add to that, which I would agree with, is that as part of the automatic criminal discovery process, there's that exchange of information. So the state is going to find out the defendant's address, and they have a process there.
Okay.
Thank you, Mr. Chair. So we've been discussing this in the context of an abuser and an abused, probably in a private residence or a private facility where the two are present and not members of the public. Let me give you another example. Suppose you have a gang, a criminal gang, and it's plotting to murder someone. And there's a person there who is planning to leave the gang. He wants out. And he has a recording device in his pocket and turns it on in order to record the gang plotting the murder of someone. If that person then were to go to the police department and turn the tape in order to explode the gang, would that tape, under the language of this amendment, would that tape be admissible because they were indeed planning the murder of someone who they wanted to get rid of? Is that a crime against a person which would be encompassed by this bill?
So two things about that, Senator. One is if the gang member, if one person in that gang meeting was outside of Maryland, it's already coming in, right? Because of the exception. So let's say everybody's in Maryland.
Probably they're not online. They're just gathered in a room somewhere.
Gathered in a room somewhere here in Anne Arundel County. It wouldn't be automatic, but yes, it would be subject to the same analysis by the court. And I would guess that it would probably end up being an analysis of the contents of the communication. The evidence derived from the communication are more probative on that point for which they're offered than any other evidence the proponent can procure. So I'm expecting that the prosecutor is going to first put that witness on the stand. If that witness's credibility is attacked or something, then perhaps then the wiretap information would come in.
So my reason I'm asking the question is because you're testifying, normally you testify on bills that deal with sexual abuse. But as I read the language of the bill, it's not limited to sexual abuse situations. It's more broad than that.
It is, sir, and one of the issues that actually has come up, again, outside of my usual client base is you all, right? We're expecting, these are laws that go into effect in October. Next year is an election year. There have been an increase in numbers of threats against elected officials. If someone calls you and you're taping that, this would allow that evidence to be introduced. So you're absolutely right. It's broader than
another good hypothetical, which we unfortunately may have to face next year.
I wish to protect you all.
Yeah, thank you.
That was impressive. Have you ever seen the movie Inception? That's what she just did to you for the bill next year, but that's good. All right. Anyway, all right. All right, with that, that'll end the bill hearing for 10:07. Thank you very much.
Thank you.
All right, that'll end the hearings for the day. And we're going to take just a reset the computer system. We're going to roll right into voting.